Hello, this is Larry Pond, and today I just want to give you a quick update from the Supreme Court. The Supreme Court just finished their 2023-2024 session for this year. And then in the fall, they'll start the new session with a whole new round of cases. The Supreme Court every year has momentous decisions to have impact upon all of us. Well, since I'm a tax person, I'm very interested in the cases that affect taxes. And in this session, there were three cases, and we're going to talk about them. So let's get started. So, a little bit about me. I'm Larry Pond. I'm a CPA, an enrolled agent, and a USTCP. I'm also a PFS, CFP, and an AEP here in Redwood Shores, California. I've been a tax professional since 1986, and I really enjoy talking about taxes. And I teach income tax at the College of San Mateo. So the three cases we're going to talk about today is the Moore case, Connolly, and the overturning or overruling of the Chevron Deference case, which we've been living under for the last 40 years. So we're going to talk about what these cases are about, what they mean to you, and what we need to learn from these cases here. So let's start with the Moore case first. So the Moore case, the decision was issued on June 20th of 2024. And in this case here, the Supreme Court held 7-2 that the one-time mandatory repatriation tax, MRT, or also known as a transition tax, that was added by the Tax Cut and Jobs Act is constitutional. This is Code Section 965. So the Supreme Court in this ruling said that Congress did not exceed its authority when it passed the MRT. So what this code section was all about was that one of the many ways to pay for the Tax Cut and Jobs Act was that it requires that companies pay tax on previously untaxed foreign profits. So this case is about Charles and Kathleen Moore in Washington State. They owned 13% in an Indian corporation that sold machine parts to rural parts of India. And this was more of a favor to a friend to help them with this business. And the name of this company is called Kissingcraft Machine Tools Private Limited. So the Tax Cut and Jobs Act passed at the end of 2017. So in 2018, the Moores learned that they were subject to the mandatory repatriation tax under the Tax Cut and Jobs Act. They never paid tax on any earnings from this company because they never repatriated. They never took the income. The income always stayed in India. It stayed in the corporation, and it was basically reinvested for the corporation. So they had never paid tax on their earnings because previous tax law allowed income earned abroad to remain deferred until it was repatriated. They had never claimed their earnings. They never got the money. Well, under this new law, under Code Section 965, the Moores were subject to tax going back to their original investment at a 15.5% tax rate, netting them a tax bill of $14,729 on $132,512 of income. Well, the Moores paid the tax, they filed their tax return, but they sued for a refund, claiming that the tax is unconstitutional. There's a lot of details in the case that we're not going to get into. There are different arguments and different ways to look at this. But the way it boils down to is the official question in front of the court was whether the 16th Amendment authorizes Congress to tax unrealized sums without apportionment among the states. So the issues that we're looking at, and this is things we learned in our first tax class, right? such as what is the definition of realization? What does Code Section 61 say? Does this mean we're going to have to pay taxes on appreciation? And Justice Samuel Alito asked, what about the appreciation of holdings in securities by millions and millions of Americans, holdings in mutual funds over a period of time without selling the shares in those mutual funds? And that was a concern among a lot of us, a lot of tax professionals, members of Congress, and especially the IRS. So the court knew that this would have wide implications. They had oral arguments in December of 2023. Oral arguments are usually scheduled for about an hour, but for this case, it went on for 2 hours. So the court's majority opinion is narrow and limited to the entities treated as pass-throughs. So it stressed that the opinion should not be interpreted to authorize any hypothetical congressional effort to tax both an entity and its shareholders or partners on the same undistributed income realized by the entity. So what they're saying here is that if you do pay taxes, you pay taxes once, not twice. The decision does not attempt to resolve the parties' disagreement over whether realization is a constitutional requirement for an income tax. Again, they wanted to narrow this decision. So in the footnote, the court said that the opinion does not address taxes on holdings, wealth, or net worth. So what the court didn't want to do was open the door for Congress to impose a wealth tax. So certain members of Congress were looking for that for that opening. So that's what the Moore case is. So unfortunately, Section 965 is constitutional. So if your clients still have any overseas investments, but they haven't realized the income or haven't repatriated the income under Section 965, it is taxable. So whilst this decision was being decided, some tax professionals were warning their clients that, hey, we might want to file a protective claim for refund in case the court found it to be unconstitutional. So this is what we learned here, but it was a very narrow decision, so it does not open the door for a wealth tax or a tax on appreciation of assets. So I think we kind of dodged a bullet on this because if the court ruled widely, it'll be a major rewrite of the tax code. Okay, so the next case that came out is the Connolly decision, and that was issued on June the 6th of 2024. And in this case here, it was a unanimous opinion. The Supreme Court found that for federal estate tax purposes, a closely held family business obligation to redeem shares of fair market value did not offset the value of the life insurance proceeds to redeem these shares. So let's talk about the background in this case here. And a lot of us have clients in this situation. We have a lot of small business clients, and there's multiple owners, and there's always a concern about what happens if you die. In this case, it was two brothers. Oh, it could be just two unrelated parties who are partners in a business or shareholders in a business. So let's talk about the Connolly business here. So it's a family business, and they had a buyback agreement. It was two brothers, Michael and Thomas Connolly, and they owned a roofing and siding company called Brown Sea Supply. And so they entered into a buyback agreement, which means that if the first brother dies, it allows the surviving brother to purchase the shares of the first brother to die. However, if the surviving brother declined, then the corporation, in this case Crown, was required under the agreement to buy back the shares. So the company, Crown Sea Supply, bought life insurance to ensure it had enough cash to make good on this agreement. And that's very common. We buy life insurance to fund a buyback agreement because that's going to provide the funds to pay for this. And then the corporation paid for the dividends, paid for the premiums. Well, Michael died in October of 2013. Check out this date here, 2013. Remember back in 2013, the basic estate allowance or basic exclusion amount was much, much lower versus today. Today, the basic estate exclusion or the lifetime exemption is 13,610,000. So for many of our clients, this might not be a problem. But back in 2013, it was a much lower amount. That was before the Tax and Jobs Act increased the basic exclusion or doubled it. Well, okay, Michael died in October 2013. Thomas declined to purchase Michael's shares. So Crown redeemed Michael's shares for $3 million. And the way they came up with this number was that it was a value agreed upon by Michael's son and Thomas, the surviving brother. Crown had a life insurance policy on Michael, so Crown used the life insurance proceeds to cover the cost. So Michael's estate paid estate taxes on the $3 million. Now, they filed the 706, and then the IRS audited the 706, and the IRS disputed the estate's valuation of Michael's shares. So the IRS concluded that the $3 million in life insurance proceeds should have been included in the shares valuations and assessed additional estate taxes. So Michael's estate, they paid the deficiency and they filed a refund suit. So, so the buyback agreement controlled the shares valuation. So, they went to district court in Missouri. They're in Missouri, district court in Missouri, and the Eighth Circuit Court of Appeals rejected the estate's refund claim. So this is how they got to the Supreme Court. So the question to the Supreme Court was whether Crown's obligation to redeem Michael's shares at fair market value offset the value of the life insurance proceeds used to fund the redemption. The Supreme Court said no. So the Supreme Court basically agreed with District Court and the Eighth Circuit Court of Appeals. So here's what the Supreme Court said. The value of a decedent's share in a closely held corporation must reflect the corporation's fair market value. Now, the life insurance proceeds payable to a corporation are an asset that increases the corporation's fair market value, because you got cash coming in. So the question is, and we've seen this in previous court decisions regarding estates, and it says, how much were the shares worth when Michael died? How much were they worth when Michael died? At the time he died, not after the redemption. Not after redemption. So they rejected the estate's view that the hypothetical buyer would pay less for Michael's shares because Crown would be less valuable after the redemption. And well, the court said the value of each share is the same before and after redemption. They rejected the estate's argument that Crown's redemption obligation was a liability. And they argued that, well, there are fewer shares after the redemption. Well, the court said, well, the result here is simply a consequence of how the Connolly brothers chose to structure this agreement. They even suggested there's other options, right? Instead of the buyback agreement they did, you can do what's called a cross-purchase agreement. And you purchase life insurance of each other. So instead of the corporation buying the life insurance, the shareholders do. And I have clients doing that. This would have avoided the risk that the life insurance proceeds would increase the share's value, but still would have allowed the surviving brother to keep Crown in the family. So use a cross-purchase agreement. So what's a cross-purchase agreement? So a cross-purchase agreement is each shareholder purchases a life insurance policy on every other shareholder. This is pretty easy when there's only two shareholders. Not too difficult, but it could be a challenge. And we run into this quite often. But that's the way it goes, is that what if you have one shareholder who's young and healthy and the other one is older and less healthy? Well, there's going to be a discrepancy with the cost of the life insurance. And that's something they'll have to work out amongst themselves. But of course, this gets a whole lot more complicated if there's a lot of shareholders. And it gets a lot more complicated if the ownerships are uneven or whatever. So there's some careful planning, careful math we have to do if we want to do a cross purchase agreement. Well, there's safe harbor provisions under Section 2703B and their regulations thereunder. They allow a contract to set the price for state purposes as long as the contract is a bona fide business arrangement. It is not a device to transfer property to members of the decedent's family for less than full and adequate consideration. The contract contains items that are comparable to other similar arrangements entered into in arm's length transactions. And then we got some more guidance from the courts for cross purchase agreements. The contract must contain a fixed and determinable price. The agreement must be legally binding on the decedent's life and the decedent's estate after death. The price set for selling the shares during the decedent's lifetime cannot be higher than the price that would be required by the estate in the decedent's death. The restrictive agreement must have been entered into for bona fide business reason and must not be a substitute for a testamentary disposition of less than full and adequate consideration. So, a lot of times is each shareholder in a small business is very important, right? If we lose you, we're going to need to hire somebody else to fill that role if you have a very important role. Depends on what role it is, right? So what's the best practice that we need to be aware of here? If using evaluation method for redemption agreement, explain the reasoning for selecting that method. Because there's multiple ways of valuing a business. And every business is different. So some methods are more appropriate than others. Cash flow, value of assets, intangibles, all those kind of things. Watch out for boilerplate language. So read the document carefully. I know we're not lawyers, but we should read it as an outsider, just to make sure it makes sense, and make sure we work with attorneys who have experience with these type of arrangements. So it might not be any lawyer you find, but it's a specialty area. So make sure we get the appropriate document. So why do we need to be careful about this now? Well, the Tax Cut and Jobs Act is expected to expire. And what happens? Well, the basic exclusion amount, the estate tax exemption amount is going to drop in half. Well, in 2024, it's $13,610,000. And most of our clients are not above that amount. However, in 26, that's going to drop in half, and we think that's going to be around $7 million, which means there's a good chance it could become a taxable situation. So just be careful with the planning and don't run into the situation that the Connollys did. All right, here's some to-dos that we need to follow here. Take a look at your client base. These are small business clients. See if they have buy-sell agreements. And instead of a buy-sell agreement, maybe a cross-purchase agreement. And take a look at the life insurance policies. Make sure they're set up appropriately, and and that's going to work as intended. Most importantly, update the beneficiary designations there. Seek professional valuation. Engage one of our colleagues who are business valuation experts, or if you're a business valuation expert. So review that. Make sure the life insurance is the appropriate amount. We might need to buy some more. Consult the appropriate tax and legal experts on this, and plan for future tax obligations. That's okay. Maybe your clients are lucky enough to have a taxable estate when they die. That's okay. Well, maybe we want to consider ways of planning for those taxes, some estate planning strategies we might need to employ. So it's going to depend on each client's situation. And then documents the agreements thoroughly. What's going to be helpful is to document how we got there. How do we do it? Well, how did we do it? So that way, in case there's any questions later, we document our thinking and our intent, just in case there's anything ambiguous in the actual agreements. So be on the lookout for your small business clients with multiple owners. See if there's any buy-sell agreements or cross-purchase agreements. What happens when the shareholders die? So we can be very, very helpful to our clients, and we don't want to run to the situation where the colonies were. Well, by the way, what's the estate tax rate? It's 40%, right? So just think of it. In the colonies case, the IRS increased the estate value by $3 million. So that's almost $1 million in tax. So this is why it's so important here. And, sometimes the logic just doesn't seem fair, but that's the way it goes. All right, let's talk about the last big case. And I think it was one of the last cases. The Supreme Court usually leaves their most controversial cases to the end. And in this case here, it's a big deal. For the last 40 years, we've been living under something called the Chevron Deference, because this came from the Chevron versus Natural Resource Defense Council in 1984. Well, on June the 28th, pretty close to the last day of the Supreme Court session, Supreme Court overturned the Chevron Deference. And the question here is how the courts reviewed an administrative agency's authority. So here's how it works. Congress writes the laws, right? And the president signs them, and the laws get passed. Well, we're tax specialists, right? Is the tax code really clear? No, a lot of times it's not clear. We're reading the code or the law that's passed, and we're saying, what the heck are they talking about? What about this? What about that? Because a lot of times when Congress writes a law, they don't think of every consequence. We do, because we're experts at it. We're living in it, and we have all kinds of questions. So the executive branch, the government, remember our civics, we have 3 branches of government. We have the judicial branch, the executive branch, and the legislative branch. With the legislative branch, they write the laws and they pass the laws. The president signs it. The executive branch, their job is to enact them, to execute them. And the judicial branch reviews these laws. They don't write the laws, but they review these laws in case they are unclear. Well, the Chevron Deference gave the agencies the authority to interpret laws, and so they get the deference there because they're supposed to be the experts. So in the Chevron case, it was a challenge by Chevron, the oil company, to the EPA's interpretation of a permitting provision in the Clean Air Act of 1977. So the courts looked at the original law to see the intent of Congress if there's any ambiguity in the language. So if the law language is not clear, the courts look at the agency's interpretation. Now, if the agency's interpretation is rational or reasonable, then the agency gets deference in its interpretation. And this is the rule we've been living under the last 40 years. There's a whole lot more to this case. We can talk about that for another hour or so. Well, in this Supreme Court session, there's actually 2 cases. I'm just naming one of them. It's the Loper Bright Enterprises versus Raimundo. And in this case here, it wasn't unanimous. It was a 6-3 majority overturned the Chevron Deference. Wow, that's a big deal. So now the administrative agencies have the burden to prove they have authority to create a rule. So Chevron cannot be reconciled with the Administrative Procedure Act, notice the APA, by presuming that statutory ambiguities are implicit delegations to agencies. The APA incorporates a traditional understanding of the judicial function under which courts must exercise independent judgment in determining the meaning of statutory provisions. So, what are the courts expert at? Legal interpretations, the law. Where are the agencies' expertise in? Well, they have specialists, right? They could have scientists, engineers. In our case, as tax experts, we get our administrative guidance from the Treasury Department through the IRS, which is the agency. So courts reviewing agency interpretations will be required to follow Loper Bright and exercise independent judgment when reviewing ambiguous statements, even in the face of on-point agency guidance. So this opens things up here. So the Internal Revenue Code authorizes the IRS to prescribe all rules and regulations for the enforcement of the Internal Revenue Code. This is all we know and love. So regulations are valid and have the force of law, force and effect of law, and that's the way we've been operating. If they implement the underlying statute in a reasonable manner, it's valid unless it's arbitrary or capricious in substance or manifestly contrary to the statute. And Treasury's done that, right? Fortunately, the way the Treasury works is we get proposed regulations, so that gives us a chance to comment on it. And sometimes, well, we've seen proposed regulations get thousands of comments saying, "Whoa, whoa, 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 that's new. We didn't expect you to give us that kind of guidance." A good example would be the proposed regulations to the Secure Act that we got in February of 2022. It kind of surprised us. Some of the provisions in there. Some of it didn't make any sense either, because some of the guidance in the proposed regulations was retroactive, which we're saying, hey, that's not fair. How could it be retroactive if you're issuing it now and it applies to last year? So, so just recently, the Treasury did issue final regulations on the Secure Act. So that was helpful. And they took our comments, and I think it's not that controversial now. So with us, with Treasury regulations, at least we have a comment period, and there's hearings, and whenever we do get proposed regulations, we have the name and email address of the person who wrote them. So in case you had a question or have a comment or have some input for them. All right. So because of this overruling of the Chevron Deference, so some other cases that come up here or other issues that come up. Well, first of all, non-compete clauses, employment contracts. Well, back in April, the Federal Trade Commission banned non-compete clauses in April 2024. Do they have authority to do that? That's a good question, right? The Food and Drug Administration, another agency, do they have legal authority on banning all non-tobacco flavored e-cigarettes? How about IRS whistleblower cases? What if your award is denied due to the IRS's whistleblower definitions rule? Do you agree with that or not? So that I think is gonna a lot of tax commentators think this is gonna really make the courts really busy. So what does it mean to us tax professionals? Well, we're probably using more weasel words with clients more often. So we'll probably say, this is probably how this works. We think this regulation will likely stand. So, there's some concerns that much of the day-to-day regulatory framework for tax will be put on hold and litigated. So, we'll stay tuned on that. So Congress will need to be incredibly specific in the statutes it passes. You think that's going to happen? Probably not. Do the Congress members know anything about taxes? Probably not. And for the last decade or so, every time we had a tax change, it was always done at the middle of the night, and they're scribbled in without hearings, and mistakes are made. We've seen mistakes, right? That's why we see a Technical Corrections Act to fix the mistakes, such as a misplaced comma, or you forgot the word not, things like that, or just all just basically typos because a lot of times these are handwritten changes and I can't figure out what those scribbles are saying. So the IRS uses the administrative and APA's notice and comment rulemaking process to make its interpretive regulations eligible for the Chevron deference. So the Internal Revenue Manual, the IRMs, is going to be updated to eliminate the state that most regulations are interpretive and not subject to procedure requirements under the APA. So we'll see what happens with that. So, um, do we invite clients to take positions counter to the IRS regulations? Because I've always followed the regulations. I don't. I'm just a simple tax professional, so I never really had an issue where I would disagree with the IRS or the regulations. But you can challenge the validity or the agency's statutory interpretation. Well, so there's different levels of guidance, right? So, the regulations, of course, are right below the law itself. And, we have proposed regulations that gives us guidance, but, they're not final, so we don't have to really follow them if we don't agree with them. But finalized regulations are more persuasive. The final regulations, here they are. Well, IRS gives us other guidances because, regulations take a long time. There are some cases where a regulation takes a decade to go final. And it's like, whoa, finally, I forgot about that one. Or there's some regulations we have out there that seem to be permanently proposed. So the IRS can't wait for that process. So they gave us notices, and we saw a lot of notices, especially during the pandemic here with the ERC rules and all. We got a lot of notices. The IRS gives us FAQs. So notices and FAQs are not law, but it gives us guidance. It gives us guidance and helps points us in the right direction. The IRS has other guidance too through private letter rulings. Yes, private letter rulings are binding on the person who wrote the letter, but again, that gives us guidance. Sometimes we get CCAs, Chief Counsel Advisory Notices. That's when the IRS agents out there are asking the national office of the IRS for guidance. Oh, I got this case here. Can you give me some guidance? So that gives us some guidance, even though they might not be law, they might not be precedent, but it points us in the right direction. Now, what if you believe the IRS interpretation is wrong? Well, you file Form 8275-R, Regulation Disclosure Statement. Good luck with that, because don't you think they'll create a big audit flag? It's like, oh, hey, this taxpayer is disagreeing with our regulations. So that could be the case. So anyway, something to look out for. I know we're going to get more guidance on this. We're going to get a lot more information about this. So stay tuned. Now, if there's any regulations out there that you have some disagreements with, love to hear from you about them, because it'd be interesting to see where this all goes. And I'm probably not even thinking about certain issues. I know we're going to see a whole lot more articles about this because we have a lot of smart, creative tax people, tax professionals out there are going to bring this up. So we'll see how this goes. So thank you for your time today. I hope this was helpful. And I put this together just to give you an update on what the Supreme Court has done in this session. Your clients might be asking about this. You might have clients with these kind of fact patterns of situations. So we just need to be aware of this and act accordingly and give our clients the best advice we can. So thank you for your time today. Look forward to seeing you again. Let me know what other topics you'd like to hear, and be more than happy to help. Have a great day. Thank you very much. Bye-bye.